The gender wars have heated up. It is Girl Scouts of America versus Boy Scouts of America. Two scouting organizations enter, one leaves, in the District Court of New York. The issue is trademark infringement. Did Boy Scouts of America infringe on trademarks properly owned by Girl Scouts of America? And if so, did they improperly dilute the brand of Girl Scouts of America? We're going to discuss this, but this is going to take a while. There's a lot of information in here. Let's get started. For more than a century, Girl Scouts of America has established itself as a preeminent, best-known provider of leadership development services for American girls. Many millions of girls have participated in and benefited from Girl Scouts of America's services, which are founded on research showing that girls learn best in environments led by girls through programs tailored specifically for girls. The core element of Girl Scouts of America's brand identity among the American public are its famous registered Girl Scout trademarks, which are powerful symbols of unique, extraordinarily valuable goodwill that has grown over decades and has been carefully protected by Girl Scouts of America. Throughout Girl Scouts of America's history, it has coexisted with defendant Boy Scouts of America, which has long offered programs aimed at boys under the Boy Scouts trademark. Like Girl Scouts, Boy Scouts trademark is a symbol of youth development programs that, for more than a century, has been aimed at, led at, and developed primarily for boys. However, the core gender distinction between the two organizations and their use of the term Scouts and variations thereof has been altered by Boy Scouts of America's recent decision to offer all of its services to both boys and girls of all ages for the first time in its long history. Let's make note that Girl Scouts of America are officially complaining the Boy Scouts of America have become gender inclusive. So isn't that just special? Boy Scouts of America is now using its trademark in a manner that is both new and uniquely damaging to Girl Scouts of America, its trademarks, and their underlying goodwill. In particular, given its significant programming shift, Boy Scouts of America is trying to alter its core brand of identity from Boy Scouts to Scouts through the use of communicative elements like slogan "Scout Me In," and the new name which will refer to its best-known Boy Scouts program, Scouts BSA, with the members being called Scouts. Since Boy Scouts of America's announcements that it would admit girls to its course programs, Girl Scouts of America's fears about the damage that would be caused to its trademarks and the mission those trademarks symbolized has been realized. Throughout the country, families, schools, and communities have been told Girl Scouts of America and Boy Scouts of America have merged, or even that Girl Scouts of America no longer exists. Only Girl Scouts of America has the right to use Girl Scouts and Scout trademarks with leadership development services for girls. Okay, interesting. This is in federal court because we are in under the U.S. Trademark Act, a provision of federal law, better known by its name as the Lanham Act to those who practice in the field, and the issues are trademark infringement, delusion, unfair competition, tortious interference with prospective economic advantage, and deceptive business practices under New York law. In more basic terms, the issue is that Boy Scouts of America is alleged to have used this Girl Scouts name when they were not entitled to it, and by doing so have gained the goodwill from that name and simultaneously diluted the value in that name for Girl Scouts of America. Let's see what their case looks like. Girl Scouts of America is a national, non-for-profit organization that was incorporated in 1915 and thereafter congressionally chartered in 1950. It is currently the largest girl-led leadership development organization for girls in the world, and its iconic Girl Scouts program is both well-known and highly regarded. Girl Scouts of America recruits and offers programs for girls in grades K through 12. The specific programs available to girls are determined by grade level. Grades K through 1 are considered daisies, grades 2 through 3 are considered brownies, grades 4 through 5 are considered juniors, grades 6 through 8 are considered cadets, grades 9 through 10 are considered seniors, and grades 11 through 12 are considered ambassadors. Girl Scouts of America's brand and program has received many prestigious awards, including being designated as a top 10 brand for the last 2 years in the World Value Index compiled by the ENSO Branding Agency, as well as numerous other accolades. Girl Scouts of America is entitled to the exclusive use of Girl Scouts and related trademarks adopted by the Girl Scouts pursuant to 36 U.S.C. 80305, which in relevant part states that Girl Scouts of America, quote, has the exclusive right to all emblems, badges, descriptors, or designations, marks, and words or phrases the corporation adopts, including the badge of Girl Scouts. The United States Patent and Trademark Office has recognized the congressional protection afforded to Girl Scouts that grant the exclusive right to use and register the Girl Scouts mark in every class of goods and services recognized by the Patent and Trademark Office under serial number 89/000078. So the Patent and Trademark Office has registered the name Girl Scouts in every class of goods because trademarks are goods and class specific, and said that this is a mark that protects all names with respect to the term Girl Scouts. In addition to these federally registered marks, Girl Scouts of America owns common law rights in trademarks as well as variation of Girl Scouts. So in addition to getting formally registered by the patent office, there are common law trademark rights so that if you establish a brand through goodwill and action, you also have trademark rights in the name. With respect to the term Scouts and Scouting in particular, by virtue of the long history of the use of Girl Scouts trademark by Girl Scouts of America, the consuming public has come to recognize Scouts and Scouting as trademark that, like other Girl Scout marks, belong exclusively to Girl Scouts of America when used in connection with leadership programs and related services for girls. The Girl Scouts mark is distinctive and famous within the meaning of Section 43C of the Lanham Act. The trademark law recognizes certain marks as being famous and distinctive, which gives them extra protection from additional appropriation. For example, a mark like McDonald's is famous and distinctive, so if someone were to register McDonald's in a class that somehow McDonald's neglected to mention, it wouldn't matter because McDonald's as a famous mark is entitled to universal registration. So that's what it's referring to. By virtue of its use, federal trademark registration, and congressional charter, Girl Scouts of America has exclusive rights to use the Girl Scout marks and prevent those uses of marks or trade dress, confusingly similar thereto. Trade dress is a name basically for the aesthetic of how something looks. So if you go into a well-known chain restaurant, like a Chili's, for example, it has a particular look. Every Chili's looks essentially similar, and they look different from every Outback, for example. You'd know one from the other. And the way that you know a Chili's is from, among other things, the way it's set up. It's trade dress. So you cannot copy the exact look of a Chili's because Chili's not only knows the name, they owe the particular aesthetic that they have developed for their brand. And that's what it's referring to. Trade dress is basically the aesthetic of the brand. While Girl Scouts of America and Defendant are both congressionally chartered corporations that offer services to America's youth, the two organizations are not associated with one another and have never been. Defendant and Girl Scouts of America have coexisted in the marketplace for many decades, with each offering youth development services and programs under the term Scouts, and Scouting trademarks. I think the coexisting nature of the brands is actually going to be a mark in Boy Scouts' favor, and here's why. As far as I can tell, the two marks have always been confused in the public's mind. The Boy Scouts of America and Girl Scouts of America sound very similar. And I think it would be very reasonable for an ordinary person to conclude that if they're not the same organization, they're closely related, which of course is not actually true. The two brands are legally and always have been distinct. But the question is, would an ordinary member of the public, upon hearing Girl Scouts of America and Boy Scouts of America, believe that they're two independent organizations or believe they're the same organization? And I think it would be very difficult to prove that many people believe they're the same organization. So to the extent that there's been a delusion or confusion of the branding, this is not a recent problem. This has always been a problem in the brand, and I think Boy Scouts of America has a fairly legitimate argument to be made that the confusion is long pre-existing. As a result of that, that this is not due to any act on their part, but due to a issue that has long since existed. Defendants historically targeted its core programming to boys, has represented its congressional charter restricting Boy Scouts and Cub Scout programs to boys, and has used its mark in connections with such brand programming. Specifically in 2004, the Boy Scouts of America admitted in a filing made in a trademark opposition proceeding that the Girl Scouts of America owned the exclusive congressionally granted rights to Scout and Scouting with respect to youth development program for girls. It further stated that the Boy Scouts controls the use of the marks Scout and Scouting with its connection with programs for boys, while Girl Scouts controls the use of marks in connections with development programs for girls. Their joint use of marks has been expressly recognized by Congress. It's a little odd for Girl Scouts to take the position, in my view, that Boy Scouts of America must legally discriminate on the basis of sex, which is basically the argument, right? The argument here is that they both have the right to use the term Scouts, and Boy Scouts has historically been rooted to boys, and because they're now going to girls, they're going against that distinction. But that means that Girl Scouts of America is arguing for the proposition that not only can the Boy Scouts of America discriminate on the basis of sex, they must discriminate on the basis of sex. Although defendant has previously offered some limited programs in which girls could participate, it has not, until recently, offered Girl Scouts programming under the mark Scout or Scouting alone in connection with these programs targeted at girls. This is a point that's going to be damaging to Girl Scouts of America, because Boy Scouts of America has not historically been strictly limited to boys. To the best of my knowledge, and of course I could be wrong, the Girl Scouts of America have strictly been limited to girls, but Boy Scouts of America have offered programs for girls, and this has not been a problem in the past. So to the extent that the term Scouting has been a problem because of the inclusion of girls, Well, they're just amplifying what's already been true. It's not new that they admitted girls. And again, it's a weird position for Girl Scouts of America to take, that the Boy Scouts of America must discriminate on the basis of sex. In January of 1979, defendant conceded in a letter that its use of scouting, which combines scouting with a merely descriptive and therefore non-distinctive term USA, could mislead the public into believing Girl Scouts of America is affiliated with BSA, or it could be confusing to donors who intended to donate to Boy Scouts of America or Girl Scouts of America. I tend to agree. The marks have always been confusing, and this is exactly the problem I was alluding to earlier. At least in 1979, I'd argue well before that, that the idea that Girl Scouts of America and Boy Scouts of America were affiliated, related, or joint organizations was an idea that was well in the public consciousness. And so if there is a confusion between the brands, this is not in any sense a new problem. So I think they're going to have some issues proving delusionment or confusion due to specifically this particular change by the Boy Scouts. In other communications sent by Boy Scouts of America to Girl Scouts of America in 1978, the Boy Scouts of America stated that it had taken several steps that should assist potential public confusion, that communicating the term Scouting USA also refers to Girl Scouts of America. So they're saying that the name can refer to either one, and that seems fine. For the one thing, we have instructed our scouters, including public relations staff, to use the term scouting sparingly, and when it is used, always to feature the words Boy Scout America. So they said they were going to use the term, but they would always try to use the term Boy Scouts of America. But the idea that both organizations have the right to use the term, and the idea that they can only use it with respect to the term on a gender-specific basis is a very odd proposition to take, given the general feeling towards non-discrimination law in the United States. Despite a century of coexistence with Girl Scouts of America in their respective exclusive and separate markets, and perhaps in an effort to address financial concerns or declining membership, Boy Scouts of America announced that it would expand its offerings under Scouts and Scouting trademark to encompass programs for girls, beginning with the enrollment of girls in its Cub Scout programs. I do enjoy the irony somewhat that Girl Scouts of America has been very critical of Boy Scouts of America for quite some time for some of its practices that Girl Scouts of America believed were improper. For example, for a long time, the Boy Scouts of America took the position that people who were homosexual could not join the organization, either as scouts or as leaders of the organization. And this was long derided by Girl Scouts of America as a discriminatory policy. And some of their more other aspects of discrimination were also derided. And now that Boy Scouts of America suddenly wants to change its position and be even more inclusive than they had ever thought before, now suddenly this inclusion level is a problem. So I do enjoy the irony that having been beaten up on its lack of inclusion, now suddenly its desire for more inclusion is suddenly a legal problem that must be stopped. In May 2018, Boy Scouts of America went one step further by unveiling a new Scout Me In advertising campaign. In announcing the campaign, Boy Scouts of America stated the Scout Me In campaign celebrates the expansion to serve families and welcome girls and boys into scouting communities across the country. Yeah, heaven forbid, right? As the May 2nd, 2018 press release also indicates, Scouts, Boy Scouts of America has been introduced as the name of defendant's program for youth who are ages 11 to 17 beginning in February 2019 and will replace the long-standing Boy Scouts trademark for programs offered to that age group. So Boy Scouts is now becoming Scouts, BSA, Boy Scouts of America. Defendant intends to use Scouts BSA mark in connection with the youth development services and programs targeted to girls. So we went from Boy Scouts to Scouts Boy, but apparently this is a problem because reasons or something, I don't know. Consistent with this message, defendant is also currently distributing marketing materials, including videos, which frequently refers to its girls as Scouts. Recent trademark filings made by Boy Scouts of America demonstrate defendant is seeking to obtain federal trademark registration rights for its rebranding effort. For example, defendant filed a trademark application for the Scouts BSA mark. Defendant has also filed a trademark application for the mark Scout Life, based on its intent to use this mark in commerce for magazines directed to interests of members in a youth organization and providing online magazines directed to the interest of a youth organization. By way of assignment from a university, defendant also owns a trademark registration for the term Scout, issued in 2015 in connection with educational services online in various fields. So this mark is actually very positive for Boy Scouts of America because it already owns the term Scout without any additional qualifier relating to educational services in at least one class. This mark was apparently not opposed by Girl Scouts of America when it was issued, and the mark has been assigned to Boy Scouts of America, which does suggest that they have the right to use the term Scout without any further qualification, at least in this domain, and is therefore suggestive of other domains. Upon information and belief, and as depicted in example 2 below, a flyer for Boy Scouts Day program held in 2018 in Texas featured the Girl Scout trademark. Well, this is a good point for Girl Scouts of America. The term Girl Scout is a term well understood to be affiliated with Girl Scouts of America. And the Boy Scouts in its advertising using the term Girl Scout would tend to dilute the term Girl Scout. Upon information and belief, and as depicted in example 3, a Boy Scout leader in Texas uses the phrase Boy Scouts of America volunteer form to recruit members online. And we can see that here in figure 3, Boy/Girl Scouts of America, which does again suggest an affiliation tie-in, affiliation relationship that is not present. So this does go to a delusion, confusion aspect in Boy Scouts of America branding, which would help to dilute the term Girl Scouts. In example 4, they point to this particular sign, Boy and Girl Scouts. Again, same idea. The term Girl Scouts is a term owned by Girl Scouts of America, and so this sign does tend to dilute by confusing the affiliation between the two names in this sign. So that does go to show some aspect of dilution or tarnishment of the Girl Scouts name with respect to the Girl Scouts brand and confusion in the marketplace. An organization in New York that sponsors Boy Scouts of America announced in October that it planned the formation of Girl Scouts BSA Troop or Girl Scouts Troop in February 2019. Example 6, a Boy Scout leader in Kirkland used the phrase, "Come talk to me about Girl Scouts BSA Troop forming in Kirkland" in a Facebook post. Upon information and belief, Boy Scout councils have used pictures of Girl Scouts in Scouts uniforms to advertise Boy Scout programming in Massachusetts, Chicago. Yeah, that's pretty bad if that's true. If you use a picture of Girl Scouts in Scout uniform in a Boy Scout advertisement, that does definitely show confusion, tarnishment, misappropriation in the marketplace. And Boy Scouts of America may have a serious problem with respect to some of that branding. Even if it didn't particularly authorize those particular instances, if they weren't authorized, it still shows confusion in the marketplace. So either Boy Scouts of America directly authorized it, which shows a direct intent to dilute, or it didn't authorize it, in which case it shows confusion in the marketplace. Either way, this kind of thing definitely shows a problem for Boy Scouts of America with respect to the term Girl Scouts owned by the Girl Scouts of America. Defendant and its counsels have also engaged in unfair business practices. For example, in May 2018, defendant's leader approached a retailer in California and attempted to dissuade the retailer from opening booth space to local Girl Scout members to sell their products, explaining defendants were supposedly serving Girl Scouts and Boy Scouts. Upon information and belief, this Boy Scout leader acted at either direction of defendant or its local counsel, on behalf of defendant or its local counsel, or for the purpose of helping defendant or its local counsel. So here they're trying to infringe on the business relationship of another organization, and there are definitely limits on when you can do that. It's a tortious interference in some circumstances to prevent another business from operating its business, and this does tend to go to that idea. Boy Scout Council representatives in Illinois directed parents at a school open house to join Scouts, representing the party's separate organizations were now combined. In addition, upon information and belief, one of the defendant's leaders at school recruitment stated there are no more Girl Scouts, or there are no Girl Scouts to a parent who is interested in signing their daughter up for GSA. Again, showing confusion in the marketplace. Upon information and belief, defendants' representatives in Texas have advised prospective parents interested in signing up for Girl Scouts that it's all the same now and that Girl Scouts are in our pack. Parents are also being told that Boy Scouts are the official Scouts, which prompted some parents to ask Girl Scouts of America representative if their long-standing Girl Scout services are properly authorized. Confusion in the marketplace, delusionment, tarnishment. There's definitely a problem here. In an effort to sow further confusion and interfere with Girl Scouts of America leadership programming and upon information and belief, defendants have used the Girl Scouts trademark and variations thereof as Google AdWords, so defendant advertisements would rank first in response to searches for Girl Scouts shop, or Google search engine. That is pretty suspicious at best. Buying ad space for a mark owned by your competitor so that when someone searches for your competitor, they find you instead, well, that definitely does tend to suggest some trademark infringement for sure. So that if the defendant really bought advertising for the term Girl Scouts, a mark that they don't own, that's definitely a problem for sure. Girl Scouts of America has been made aware of several instances in which girls mistakenly signed up for Boy Scout programs when it was their intent to sign up for Girl Scouts. In central Indiana, a parent contacted Girl Scouts and reported she had mistakenly enrolled her daughter in the Boy Scouts when she believed that she was signing up for Girl Scouts. Again, showing confusion in the marketplace. If a consumer buys one thing, believing it is another thing, that is classic examples of confusion. Actual confusion in the buying of a product is a trademark confusion that shows an infringement aspect. So there is legitimate aspects of confusion in the marketplace. These are reasonable consumers engaged in this, so this is something a reasonable consumer could do, make this mistake, and this is a problem. I would wonder, though, how often this happened in the past. How often did this happen in the 1980s? How often did a boy attempt to sign up for the Girl Scouts, or how often did a girl attempt to sign up for the Boy Scouts, believing they were the same thing? So, to the extent that this is a confusion, I don't know it's a new confusion. This may have always been a confusion. I think that there's always been a problem where people have thought that these are related brands when they haven't been. And so I bet you fairly confidently that there have always been girls who have tried to sign up for Boy Scouts believing it's the Girl Scouts. Now, in the past, they weren't able to do this, but there's always been that confusion aspect. And I don't think Boy Scouts of America merely letting people sign up when they couldn't before, in and of itself, creates a confusion. I think the confusion was already there, and I think that part of it is going to be a bit of a problem for Girl Scouts of America in pressing their complaint forward. Upon information and belief at a school recruitment event, a mother filled out a membership paperwork provided by Boy Scouts, believing she was signing up her 5-year-old daughter for Girl Scouts. Iowa provided information on a recruitment flyer for a defendant that said, Scout troop starting, all elementary school children welcome, which was billed as a Girl Scouts event and posted on the website as such. Upon information and belief, defendant use of the term Scout, Scouting, and variations thereof, like Scouts BSA, with all of its core programs offered to girls nationwide, has caused an extraordinary level of confusion among the public and violated valuable trademark rights. Such improper associations are of particular concern to Girl Scouts of America because defendant has received significant negative publicity regarding its activities conducted under the Boy Scouts and Scouts marks, such that the goodwill associated with its terms and connections with the Boy Scout Leadership Program services has been damaged. In particular, there have been lawsuits and medical articles alleging poor child safety record with respect to certain aspects of defense program, acts of misconduct perpetrated by some of its leaders, and by Boy Scouts of America's decision to lobby against child protection statutes in certain states. I don't know what particular instances they're referring to, but with an organization as big as Boy Scouts of America, it's not too difficult to believe that there have been instances like that. And I bet you that if we looked at Girl Scouts of America's history, we find a comparable number of instances of complaints against Girl Scouts of America, because it's just unlikely that organizations this big wouldn't have problems this wide. When you get enough people together, there are going to be issues, and this seems somewhat par for the course. All right, let's get into the causes of action. Now that we have the factual background, what are we asking for? First cause of action is trademark infringement. Without Girl Scouts of America's consent, defendant has used Scouts and Scouting marks which are confusingly similar to Girl Scouts marks. In addition, defendant's counsel's troops at the direction of defendant have also used the marks which are confusingly similar to the Girl Scout mark. Defendant's actions are willful and reflect an intent to confuse consumers and profit from the goodwill and consumer recognition associated with Girl Scouts of America and the Girl Scout marks. Defendant infringement of registered mark is deliberate, willful, and without extenuating circumstance, and constitutes a knowing use of Girl Scouts of America's trademarks. Defendant infringement is thus an exceptional case within the meaning of Section 35, and therefore Girl Scouts of America is entitled to receive 3 times the amount of normal damages. So under certain circumstances at law, there's what calls triple damages, or what's also called treble damages, which is exactly the same thing. You can receive 3 times the damages you would normally receive. And Girl Scouts of America is saying that under the Section 35 of the Lanham Act, this is an exceptional case. I think they have a viable argument it is, given the fact that this is a famous mark and there's some instances here. This could fall within the scope of an exceptional case. So they're right to plead it. More would have to be proven, but there's enough to make at least the initial allegation. Second cause of action, unfair competition and false designation. Defendant's counsels at the direction of defendant have used the marks, which are confusingly similar, in commerce in connection with services targeted girls and advertise and promote such competing services. Defendant's actions, as well as those of its counsels and troops, are likely to cause confusion, mistake, and deception to consumers as the affiliation, connection, or association of defendant with Girl Scouts of America as the true source of defendant services and the sponsorship. Again, I'm not sure this is necessarily a current or unique problem of the current situation. I have a sneaking suspicion that this has always been a problem in history, and I imagine that one of the Boy Scouts of America's defenses is going to be exactly this, that these marks have always been confused and that the level of confusion is not attributable to these particular acts. In fact, I wouldn't be half surprised if Boy Scouts of America attempts to argue for genericide that both marks have no particular value because the level of confusion for both has become so diluted. So Boy Scouts of America may go for the dire option of saying neither one sets of marks are valid, and they have a plausible claim to be made because of the level of confusion that's been made historically. Defendant's unfair competition and false designation are deliberate, willful, and thus entitled to triple damages under Section 35 of the Lanham Act. Third cause of action, federal trademark delusionment under 15 U.S.C. 1125. Without authorization, defendant is using and intends to use scout and scouting trademarks and marks similar thereto in commerce in a manner that impacts the distinctive quality and harms the reputation of the Girl Scouts of America famous Girl Scouts mark. At least with respect to this particular aspect, I think that Girl Scouts of America have a bit of a problem. In their own factual pleading, they tended to imply that both the Boy Scouts and Girl Scouts have the right to use the term Scouts in their respective organization, at least with respect to their individual genders. So the issue isn't the word Scouts or Scouting, even from Girl Scouts of America's point of view. The issue is that they're now using it in a way that implies that both genders can join. And it seems very odd indeed that the term is gender restricted and must be gender restricted. I think public policy considerations would tend upon such a construction, and Girl Scouts of America is going to have a difficult time arguing that Boy Scouts of America is required to discriminate on the basis of sex, which is what this argument is basically going to. The acts of defendant alleged herein, as well as those of the counsels, occurred after the mark became famous and constitutes delusion by blurring and delusionment by tarnishment. Blurring is where the marks become blended, so you can't tell one from the other, and tarnishment is where a mark becomes harmed because of a false association, so it becomes weaker than it should be otherwise. And they're citing Section 43 of the Lanham Act. Upon information belief, the acts of delusion and tarnishment are willful, deliberate, and in bad faith. Fourth cause of action, modification or cancellation of registration. Defendant's trademark registration for the term Scout, obtained by assignment, does not limit the identified online avocation to program for boys. Pursuant to 15.1119, this court has authority to determine the right of registration or to cancellation in whole or part, and otherwise rectify the register with respect to registrations of any party. Consistent with the authority conferred, defendant's mark for Scout should be modified or canceled through an entry of decree to say that it must be limited to boys. Well, the problem here for Girl Scouts of America is that this term Scouts became registered, and when it became registered, it was published for a notice that it was going to become registered. This was published in the public register. So every time a trademark is about to be issued, the United States Patent and Trademark Office puts a notice about it in the public record, and in case anyone wants to oppose it. And neither the Girl Scouts of America nor Boy Scouts of America apparently opposed it, and even if they did, the mark was granted anyway over whatever objection they gave. So the problem here for Girl Scouts of America is they already had their opportunity to cancel the mark. Nothing about the mark has changed. It was always intended for online use. And so the mark is and was being used for its intended purpose. So Girl Scouts of America does have a bit of a problem in saying why the mark should be canceled or changed now when they already had the opportunity to make that opposition as part of the trademark grant in the first place. Fifth cause of action, common law trademark infringement, unfair competition, and passing off. Defendant's unauthorized use of trademark confusingly similar to Girl Scouts in connection with youth development services or programs for girls is likely to cause confusion as the source or sponsorship of these services and likely to lead the public to believe the Girl Scouts is affiliated with the defendant or defendant services, likely to mislead persons in ordinary course of purchasing defendant services, damaging reputation. Again, the Girl Scouts of America is making the argument that Boy Scouts of America cannot sell its products to girls. It's like, can you see anything wrong with the optics of this position? Because it is a very odd position for Girl Scouts, an organization which has somewhat prided itself on inclusion, to make an argument that another organization is not allowed to be inclusive, especially when they have previously criticized that exact same organization for not being inclusive in the past. This is a very awkward position for Girl Scouts of America to make, and I think it's going to run into all kinds of problems, not the least of which is public policy considerations. The court is not going to order that an organization must discriminate on the basis of sex. That would be very weird indeed. Upon information and belief, defendant has the authority to control its use of the intellectual property related to its services and reaps a direct financial benefit from wrongful activities. Well, that much I suppose is true. It does have the right to control its intellectual property, at least to some extent, although with an organization as big as Boy Scouts, it's unlikely that they have that much control to really control its troops, but they might be liable for it anyway as they are subsidiary organizations of the parent organization. In any case, the Boy Scouts of America does tend to reap some financial benefit with respect to what its chapters are doing, so there is a fair point to be made there. Defendants' acts of unfair competition, trademark infringement, passing off, unless stopped by this court, will threaten the Girl Scouts of America irreparable damage for which it has no remedy. Girl Scouts of America is therefore entitled to injunctive relief for such wrongful conduct and award damages. Well, if it is wrongful, they are entitled to injunctive relief, although that presumes that they're the conclusion that they're trying to reach, and I am somewhat doubtful that they ultimately get there in the end, at least with respect to the term Scouts, although I think that they're more likely to get there with the term Girl Scouts. Sixth cause of action, trademark delusionment under New York general business law. So although we are in federal courts have what's called supplemental jurisdiction, because we don't want multiple lawsuits to file the same thing. So if you have the right to be in federal court, you can also bring in state claims. So this is a state-specific claim, but it can be brought into federal court because there's at least one viable federal claim, and so supplemental jurisdiction allows the federal court to also hear the state claim, so we don't have to have multiple cases in multiple courts, possibly reaching multiply inconsistent conclusions. Girl Scouts of America's mark is distinctive within the state of New York and has been for many years. Defendants have used the term scouting and marks similar thereto in New York in a manner that impairs distinctive quality. Seventh cause of action, tortious interference. Although there is a general right to compete in business, there are rules in business on what you can and cannot do. And there are some kinds of interference in business that are considered against the law, tortious interference, and that's what's being alleged here. Defendant is aware that Girl Scouts has a prospective business relationship with the girls who attends recruitment. Defendant's recruiters have told parents and girls there are no more Girl Scouts or the organization have been combined. These statements are dishonest, unfair, and improper because Girl Scouts of America is still in existence. Defendants cannot register girls for Girl Scouts program. Upon information, believe these recruiters acted upon to defend behalf of defendant or for the purposes of serving the defendant interest. It's unclear how much control or direction these recruiters really had. I mean, we were talking about a nationwide organization, and these are probably just parents volunteering. So it's very likely that these people were just simply confused. Either way, Boy Scouts of America has a bit of a problem because either they directed it, in which case they're liable, or there's confusion in the marketplace, which shows a delusionment, which gives a strong claim to Girl Scouts of America. So whether or not they ordered it directly or not, there's still a problem that people are doing this because it shows confusion in the marketplace. Girl Scouts of America has a prospective business relationship with a retailer to provide space, and defendant knowingly, intentionally interfered with this relationship. That would be a problem if it's true. Prayer for relief. Okay, what are we looking for? Girl Scouts of America requests the following. Preliminary and permanent injunctive relief. Preliminary and permanently enjoined from using the Girl Scout marks or any confusing similar variations in connection with marking, sales, or rendering of defendant services. That much I think that they will likely get. You can't use any mark legitimately owned by Girl Scouts. I think that's a fair request. Using the marks Scout, Scouting, or BSA or any variation thereof alone or without any inherently distinctive or distinguishing term immediately before it in connection with marketing, promotion, advertising, sale, or rendering any defendant services directly to girls. This one seems less likely to me. First of all, I would take personally the position the term Scout is generic. If a term is generic, anyone can use it without limitation because no one can own it. So if you make a product of acetylsalicylic acid, you can call it aspirin. Anyone can call it aspirin. It's no longer a brand protected name. And for the same reason, I don't think the term Scout, Scouting, or Scouts are protected. I think that they are generic terms and anyone can use them. Because here's the question. If you wanted to refer to it in a generic way, what else would you call it other than Scouting? What would be the generic term? And I'm not sure there is one. I think Scouting is the generic term for this. So I think a court is likely to rule that the term is generic and no one owns it. In the alternative, if they are owned, both people have an equal claim to it. And I don't think a court is going to be likely to say that they have to discriminate on the basis of sex. So I think that Claim 2 is not as likely as Claim 1 is. Using any false designation of origin or false description that can or is likely to mislead the public to believe any service is in any manner associated with or approved by Girl Scouts of America. Yeah, fair enough. We might have to put in some kind of disclaimer or something, or we might have to be a little bit more careful in some of our advertising. I think that's a fair request. Representing in any manner defendant as counsels or endorsed or sponsored by Girl Scouts or represent the work on behalf of Girl Scouts. Yeah, that's true. You cannot say that you're endorsed by or working on behalf of or otherwise representing Girl Scouts when it's not true. So that's fair. And any other infringing or misconduct discovered during the conduct of this action. Okay, fair enough. Some of that's reasonable, some of it's not, but I think it's definitely reasonable with respect to the marks Girl Scouts of America specifically and exclusively owns, including the term Girl Scouts. I don't think Boy Scouts of America can legitimately use the term Girl Scouts or its variants. So I think that much is certainly a reasonable request. Defendant be ordered to provide training. Fair enough. I mean, obviously there's confusion in the marketplace. I'm not sure this is a new problem, but the defendant has to help make sure the marks are not confused with its agents. So, yeah, I see no problem that Boy Scouts of America would have to provide additional training to make clear what are and are not its marks and make clear Girl Scouts of America, the uniforms, the badges, the names of Girl Scouts that are exclusive to its brand. Yeah, I think that being ordered to provide training is a reasonable remedy. The defendant be ordered to withdraw without prejudice various trademarks that are before the PTO. Maybe, maybe not. There's really no particular reason for the court to necessarily grant that action because the marks can be protested at the Patent and Trademark Office. They're currently pending. So the Girl Scouts of America can just go fight them over there rather than fight them over here. There's nothing stopping a court from doing this, but there's no particular reason for the court to do it either. So we'll see how that goes. A declaration certifying the manner in which they've complied with terms of injunction. Fair enough. Judgment be entered that the mark that's been issued is modified or canceled. This is the mark for the term Scouts with respect to its online marketing or limiting services and programs for boys. I think that's a bit unlikely because the mark already exists. There was already a protest period. They're using it in combination with the mark for its intended use. I don't think cancellation is the likely remedy in this situation because there's nothing that's changed since the mark has been issued. Defendant is declared to have engaged in acts that violate common law, trademark infringement, unfair competition, passing off. Defendant is judged to have violated the business law by diluting the mark. It's judged to be liable for tortious interference. Award damages sufficient to compensate, so we're looking for monetary compensation, fair enough. Accounting of profits earned from result, also fair enough. Try to account for how much we've earned as a result of any misdeeds we've done. That's reasonable. Award 3 times profits and 3 times damages as a result of willful deliberate acts. Fair enough to ask for it. Unclear if they'll get it at this point, but they are a famous mark, and some of these issues do tend to go to extreme issues. So there is some elements here that at least cause us to ask for it. We want to be awarded attorney's fees and costs. We want to be granted judgment, and we want to be granted such further relief. Well, there's certainly a lot in here, isn't there? This trademark issue is pretty good. So we've got 2 different issues basically when it comes to trademarks. We've got marks that are clearly owned by Girl Scouts exclusively and the joint owned marks. So the joint owned mark is probably the term Scouts. Can Boy Scouts of America use the term Scouts? Well, Girl Scouts of America says it's a jointly owned term, and it's always been used with respect to boys. So they must be able to use it. And it seems a very difficult proposition. The court is going to say you can only use this term with respect to boys because that means effectively they have to discriminate on the basis of girls. So Girl Scouts of America is taking the position effectively. Boy Scouts of America must discriminate on the basis of sex. That's a very odd proposition to take. I also think the term Scouts is a generic term. I think that a court is going to find the term Scouts as generic, that anyone can use it, and it's a non-protectable mark because there has to be some kind of generic term so that anyone can refer to the thing by a generic term. So, if you want to call a car, that's fine. I mean, only Toyota can call a Toyota, but anyone can call a car because it's a generic term. And same thing for acetylsalicylic acid. Anyone can call it aspirin. So the question is, what is the generic term for scouting, if not scouting? And I can't think of another one. So I think the term scouting is likely generic. And if it's not, I think either one can use it. So I think for that aspect, Girl Scouts of America loses. For the question of the marks such as Girl Scouts, its uniforms, terms like Brownie, term like Ambassador, its Gold Award, its particular badges that it issues, those kinds of things where people are using the term Girl Scouts and Boy Scouts referring to troops and things like that, I think Girl Scouts of America wins. And now how much they win is unclear, but there's definitely some instances of confusion in the marketplace. Now the real question is how much of this confusion is new and how much of it is latent. Because I have a sneaking suspicion a lot of it is latent. I have a sneaking suspicion that Girl Scouts of America and Boy Scouts of America have long been confused in the marketplace. I think that trying to isolate this particular level of confusion is going to be an issue. And I think that's a really interesting defense from Boy Scouts of America if they choose to go that way, is to say that, look, these terms have always been confused. And so there's just massive confusion in the marketplace, and so it's not really a big problem. They could go for the real extreme option of saying neither one's marks are valid at all. So they could completely genericize all the marks. I don't think Boy Scouts of America is going to do that because they want to have something left for themselves. But I think they could definitely try to take the more moderate position of saying that these marks have long been confused and that there's really nothing new here. I think that argument is not likely to ultimately win the day because Boy Scouts of America has engaged in practices that has created confusion. When Boy Scouts of America admitted that it was going to admit girls, I have no problems believing that a lot of people believed that Girl Scouts of America was finished as an organization and that they were merged and there was a formal cooperation. So I think there is some damage to Girl Scouts of America. How much damage, what that damage extends to is yet to be seen. But there are some legitimate complaints here by Girl Scouts of America. I think the real issue for Girl Scouts of America is that they're just concerned that they're done as an organization. Because I think that they think that Boy Scouts of America is a more fun organization that offers more interesting things to do. And I think that they think that a lot more girls are going to join Boy Scouts of America, and it's just going to become uneconomical for Girl Scouts of America to continue as an organization. I think Girl Scouts of America's real concern is that they're done as an organization. And to be quite frank, I tend to agree with them. I think they are done as an organization. I think that they're dead and they just don't know it yet. So Girl Scouts of America may win parts of this battle, but I think Boy Scouts of America is going to recruit more girls. It's going to become more popular. More girls are going to join. It's going to become more popular. And I think all the cookie sales in the world are ultimately not going to be enough to keep Girl Scouts of America afloat. I think Girl Scouts of America is done as an organization. And this is a last dying breath of a organization that realizes that its time has come. I think that's what's really going on. So that's my. I think Girl Scouts of America is going to win parts of this lawsuit. How much damage they're going to get, I don't know. They'll get some injunctive relief, I'm sure, but it's not going to be enough to win the day ultimately. I think Girl Scouts of America is ultimately done because I just think Boy Scouts of America is a more interesting organization, and I think a lot of people see it that way. And I think that I don't know a lot of boys who want to join the Girl Scouts, but I know a lot of girls who want to join Girl Scouts. And now that they can, yeah, I think this is a thing that's going to be a real problem for Girl Scouts of America. So, but that's how I see it. How do you guys see it? I know this has been a long video, but there's a lot to cover. Hope you're all my friends. Until later, cheers. Bye.